Good morning. We have quite a few of you joining us this morning. And so we'll just give one more minute for people to continue joining the session. We would like to thank you for actually attending not only this session, but this is the fourth session in our Fair Housing Training Series. So want to thank you again for your support throughout the last 4 weeks. Today, we're going to be talking about housing protections for survivors of gender-based violence and immigrant households. We just want to give you a few housekeeping notes. So one, we want you to just keep in mind that today you are not receiving legal advice. This is just fair housing education. Also, we want to encourage you to put your questions either in the chat or the Q&A section. We will answer questions at the end of the session. We're going to try to make sure that we have ample time for Q&A at the end. We will also make sure that you get copies of the presentations from this and all of our sessions. We do have a link that we will share with you. And then finally, if you want to receive a certificate for attending all 4 sessions, we need you to do a few things. So number one, if you are joining us by phone, we can't see your name. So we'll need you to make sure that you contact Nastasha Flowers. At her email address is here on the slide, and she is the contact for our sessions. So you should reach out to her so we can make sure that we have your name down. In addition to that, we do have an exit survey for the session, and we value your feedback, and we will make sure that we get you a link to that session, and you'll see that in the chat later today. And that also helps us because for our session 2, 3, and then this one, which is session 4, we want to make sure that you fill out that exit survey, and that will help us to keep track of who should receive that certificate of completion. Again, if you joined us for the first session, we did not have an exit survey, but for sessions 2, 3, and 4, we do have a survey. And finally, just to, again, go over the agenda for today. First, we will have Jackie Correa from the network, and she's going to discuss survivors of gender-based violence. After she speaks, we will have Nareen Kim, who is from the North Suburban Legal Aid Clinic, and she will talk about protections for immigrant households. So I'm going to turn it over to Jackie.
Hi, everyone. All right, I am going to share my slides. There we go. All right, welcome everyone. I'm so glad everyone could come. I was really excited to do this. I really love talking about this topic. So for those of you that don't know me, my name is Jackie Correa. I work at the network, as Gianna said. I'm the director of housing advocacy there. So that means a lot of things. I wear a lot of different hats in my current role. A lot of times I work with survivors directly. Sometimes I get calls off the hotline about housing legal issues. I do a lot of policy work. I do trainings like this, do a lot of work in the continuum of care. I meet a lot with providers and try to increase access to housing. And then I troubleshoot different housing issues with people all the time, whether it's caseworkers, other attorneys, survivors themselves, people in shelter. And so every day looks very different for me, but I'm really happy to be here, like I said. So I've been at the network for about a year. Prior to that, I worked at Legal Aid Chicago for a little over 6 years, where I directly represented survivors on housing issues. And so I would defend against evictions, subsidy terminations. I would help people with fair housing cases, sexual harassment, and things like that, lock changes, lease terminations. So everything I'm going to talk to you about today are things that I've done before, things that I still continue to do. And so I really welcome any questions. Like Gianna said, you can put them in the Q&A. Yeah, all right, so let's jump in. So Just so you know, a lot of times when I'm doing a presentation, I talk about cases I've worked with, obviously not using identifying information, but I just want to let people know that I may talk about, sexual assault, domestic violence, gender-based violence. I don't want it to be triggering for anyone. I just want to give you just a heads up about the content of the presentation in case some of those examples come up. And also, my slides are kind of a series of infographics because I think that might be most helpful in case you want to use them later as you're working with survivors. So I've tried to organize things more by topic and then the protections underneath versus the protections. So all right, let's jump in. So before we get into the presentation, I have a question for all of you, and I'm going to put the link in the chat and ask that you fill it out. But my question for you is, what do you think are adverse factors that are related to gender-based violence in housing? And there's a reason I'm asking you this, and I appreciate it if you can click on the link and submit some words, but I'm looking for things like poor credit history, debt, job loss, lost wages, property damage, noise complaints, justice involvement, unpaid bills, unpaid rent, substance abuse, DCFS involvement. So there's a myriad of things, but when you think of adverse factors that are related to gender-based violence, what do you think of? And then I'm going to switch so we can see the results as they come in. So I see someone says instability. And so if you haven't used Mentimeter before, you should be able to see it now, but let me see. So now people should be able to vote, and I'm just going to put the link here. So I see some responses are coming in. Some of the things I mentioned, I also see in the chat. Instability, low income, complex trauma related to domestic violence, PTSD, there's no wrong answers here. And I love a question that has no wrong answers. So everyone should feel welcome to submit responses. I'll just give it another minute for people to fill out. I'll put the link in again so we don't get lost in the chat because we've got a lot of people on the line. So I'll just give another minute. The nice thing about a word cloud is that if you see something that resonates with you on the screen, you're welcome to resubmit it because it's going to give a better picture of what we think as a group, right? Because the words that are submitted more often or the phrases that are submitted more often are going to be larger. And so it's going to emphasize kind of what we think most often when we're answering this question. So I'll just give it about 30 more seconds. We'll see where it lands up. And obviously it's continuing to adjust as people submit responses. Okay, and I see some more in the chat too. Let's see, insecure housing instability, repeated safety moves, intellectual disabilities, mental illness, mental health, financial instability, family, lack of inaccurate information, depression, like I said, no wrong answers here. Let's see. Okay, so a lot of the ones that are emphasized in the cloud, as you can see, mental health, mental illness, police involvement, instability, housing instability. I see in the chat, we've got missing vital documents and records, substance abuse. So, and like I said, these are all good answers, right? Because gender-based violence, it's not something that you can look at in a vacuum, right? It really spreads throughout your life. It affects you in a lot of different ways. So I want you to kind of think about this as I go through some of the things I'm talking about, because when we talk about VAWA, a lot of things are related to this type of definition. Like it has to be an adverse factor related to gender-based violence. And HUD perceives that very broadly. And so I want us to perceive it really broadly too. So before I go back to my slides, I also just wanted to flag for you on the network's website, we do have materials for download. I'll put that in the chat. A lot of these I've created myself, and some of them are helpful to give out to survivors. I've got ones about safe reentry, Safe Homes Act, Violence Against Women Act. There's also this poster about the hotline. So if you're ever looking for resources to hand out about some of the housing issues I'm going to talk about, those are right there in case you need them. All right, jumping back to the slides. Okay. All right. So working with gender-based violence survivors. So a lot of you probably work with survivors in your everyday work. Statistically speaking, even if you think you don't, you do. And so a lot of times when I'm working with a survivor, my initial thought is about addressing an immediate housing safety concern. And that can be done in a variety of ways. So when you're working with a survivor, a lot of times they've been in a relationship where there's been a severe power imbalance. And so it's always important to kind of work with them in partnership and build them up and let them make the decisions that are best for them. And so these are just a series of options, but obviously some options are not going to work for some people, and that's completely fine. So one of the first things I have on here is just highlighting the hotline, open 24/7. It's free, it's confidential, it's available in a number of languages. So the hotline connects people to shelter services. We can also do Ubers to safety, which I think is a lesser known service that we do. But sometimes that can be kind of an immediate crisis triage, especially if you're trying to get someone to shelter. And the hotline operates statewide. Survivors can consider getting a protective order. I will note for almost all housing protections, you do not need a protective order, but sometimes people want one, especially if they're trying to stay in place. Sometimes a protective order can be helpful. But like I said, not everyone wants to get one. That's completely understandable. A lot of people, some of our systems are very broken, and a lot of people don't want to interact with them for very justifiable reasons, but it's certainly an option if people want to pursue it. One of the housing remedies available through a protective order is to get exclusive possession of the home, which can be really beneficial. Like I said, if someone wants to stay in place and if it's safe for them to do that. There's other housing remedies too, though, that you can get a protective order, including figuring out what's going to happen with the perpetrator's items. That's a common thing where things are left behind and there's this gray area about what's going to happen. Protective orders can also, in addition to prohibiting entry generally to a place, they can prohibit entry if someone's under the influence. One of the last kind of immediate safety concerns that I think about, especially, like I said, if someone wants to stay in place, is considering a lock change. So in Illinois, we do have the Safe Homes Act, and it creates two pathways for a lock change. If the survivor has a written lease and they are the only person on that lease, aside from like children or, non-violent roommates, then they can get a lock change if they request it in writing, because there's a threat of domestic violence or sexual violence. And they must support it with like medical, police, or court evidence, or a statement by a victim service provider. If the perpetrator is on the lease, then you need a plenary order protection to get a lock change. Or if there's an oral lease, you also need a plenary order protection to get a lock change. I'll just note that if someone does want their locks changed, a landlord can charge for it. However, the charge has to be reasonable. Okay. So pathways to housing. I think there's this common assumption that if someone needs housing in an emergency situation or due to gender-based violence, that we have an immediate option for them. And a lot of times we don't. So like I said, the network through the hotline often gets people to shelter, and every day kind of confirms where there's availabilities. Frequently, there are no spaces in the city of Chicago. I would say about 30% of the time when people call the hotline, they're looking for shelter. And about 30% of the time in the city of Chicago, there's no beds available. I would say about 60% of the time, there's no cribs available. And that's important because a lot of survivors have young dependents. But emergency shelter can be one option for someone, and sometimes people have to travel very far to get there. Another pathway is the domestic violence human trafficking coordinated entry system. Unlike the general coordinated entry system where you have a lot of very open access points, for this system, you usually need to be referred by someone that's working with survivors, and there's some training that goes into that. If you do regularly work with survivors and you want to be referred and connected to that system in the city of Chicago, let me know. I'd be happy to connect you. Through that system, survivors can be matched typically with rapid rehousing or transitional housing. So those are 12 to 24 month kind of time limited programs. However, often they can help people get back on their feet after they've experienced violence. Another pathway is that housing providers can identify preferences for people or prioritize survivors in housing. I see a lot of housing providers that do that, and it really does make a difference. What it does is it helps them kind of rise up the wait list a lot quicker than other populations. One of the reasons it's helpful is because depending on where you live, it's really difficult to get into subsidized housing. So having that preference can really shorten the time frame that you wait on that list. And by taking a long time to get into subsidized housing, in some places it's 25 plus years. And so a preference can cut that down to maybe 4 or 5 years, which is still very long, but it's obviously about 20% of what you might experience otherwise. And then I have just kind of a catch-all others. A lot of times there's new programs that come on board that might have a preference for survivors, or that might have a little bit of a set aside or a carve out. Sometimes the city will do that. Sometimes municipalities will do that. Sometimes HUD will do that. The EHVs, the emergency housing vouchers, is an example of when that happened. So whenever there's new programs coming on board, I'm always looking at it to see, is there a way for us to get people in housing? All right. So the first thing I'm going to talk about is early lease termination. So someone comes to you and they say, you know what, I need to end my lease. I need to move. I don't feel safe here. So I do have the infographic on the website, but you're also welcome to use this. So when someone needs to terminate their lease, there's two pathways. And the first one is on the left, and it's the easiest way for someone to terminate their lease. And it's for survivors of domestic violence or sexual violence under a credible threat of violence. And I see that I have an A in credible, which is going to drive me crazy, but I am sorry about that. So we're talking about the left side. So if someone's under a credible threat of violence, they need to do written notice to their landlord 3 days before or after they leave. Like I said, they need to be under a credible threat, and they don't need any other documentation. All you need to do is that written letter. So that is the easiest way to do it. Survivor statement on their own is enough. I always like to make sure it's confirmed by the landlord, make sure everyone's on the same page. So that is one way to do it. For survivors of sexual violence, the law recognizes that that credible threat doesn't always exist, right? Sometimes, especially, when you're thinking about sexual assault, it may be a one-time incident where you don't really know the person, you don't expect them to come back, but you still feel kind of unsafe and need to move. And so for survivors of sexual violence, they can also terminate their lease by once again providing written notice 3 days before or after they leave the unit. And there has to have been sexual violence at the premises within 60 days. Unlike the first pathway, for this specific sexual violence carve out, you do need to include police, medical, or court evidence or a statement from a victim service provider. So survivors of sexual violence really have the two pathways. If someone's under a credible threat, I usually recommend that they use the first one just because it's straightforward and you only need the survivor statement. If a survivor of sexual violence is taking the second pathway, where they're not under a credible threat and they have to support it with documentation, I always recommend that they use the most helpful, least invasive evidence to support their requests, and that typically means a statement by a victim service provider. When someone is kind of wrapping up their lease, they're terminating their lease, they're moving out, if they can, which is not always the case, but if they can, I always suggest that they try to wrap everything up with the tenancy. Make sure that there's no balance, make sure that the landlord knows where to return a security deposit, do a walkthrough, make sure that that's all tied up so that it doesn't come back to haunt the survivor later. Once represented someone who, I want to say it was about 3 years after she moved out, was sued in a small claims court for about $11,000 based on a Safe Homes Act termination. And there was no question that she did the termination, but they were still trying to collect. We did successfully defend it, but it's always nice to have kind of that coverage if issues come up in the future, that you've got your written notice, it's unquestioned that happened, that you confirm with the landlord that you moved out, that you returned the keys, things like that, making sure that it's all tied up and documented. All right, so next, moving on to barriers to housing eligibility. So a lot of times when survivors are applying to housing, they get denied or they get turned away. And so often there's something you can do. And I also have some suggestions for proactively addressing barriers. I find this to be particularly problematic for survivors that have justice involvement on their background. Although it does affect survivors generally, because a lot of times they haven't been the primary income earner in their household. They may not have a strong credit history. There may have been financial abuse. There's so many reasons why this could be an issue, but here's some of the things that you can do. So, so there is protections against discrimination. And so what I have here is 2 bullets. The first one is kind of these really niche, defined, protected categories specifically for survivors. And I love these because it's such a nice line from point A to point B. So I've got a list here, and it's varied where these come from. So housing status is from Cook County. And let me see. Actual perceived survivor of domestic violence, which is really what you ultimately want. That's from Evanston. I helped get that passed a couple months ago. Order of protection status is from Illinois Human Rights Act. But my point is, in most of our fair housing statutes, there are these protections that exist there that say that you can't discriminate against someone based on them belonging to this category. And so those are nice if you have them. If you don't, survivors are still often protected under the more broad categories that are in almost every single fair housing law that you might experience. Fair Housing Act, Illinois Human Rights Act, Cook County, Chicago, Evanston, other local ordinances, they almost always have sex, disability, familial status. And so survivors are often protected within those. And so based on the reason for denial, you may be able to raise a discrimination issue and ask for it to be reconsidered. I usually do that in a letter and kind of outline what the issue is and why I feel like it fits within the protected category. Just as an example, I once had a survivor apply to an apartment, and she kind of explained what was going on in her background. The person that was harming her was very violent, and that's why she needed to move. And the landlord wrote a letter and said, I will not rent to someone who has an order of protection. So I mean that's very clear cut there. It's not always like that, but it's just a good example of how you can follow up and address that and why it's problematic behavior under the fair housing statutes. Gianna, should I leave questions to the end, or should I answer them as they come up in the chat?
I see one question there, and let's go ahead and answer this one.
Okay. So the question in the chat is, what kind of evidence needs to be presented to legally get an early release from a lease? Can someone simply say they're being abused with zero mental, physical evidence of anything occurring? Great question, Todd. So it depends on how the person is trying to terminate their lease. If they have, number one, it does have to be in writing. There has to be, the person has to identify that they're experiencing a credible threat. But if you're looking at this left side, if there's a credible threat and the person's a survivor, yes, the answer is there doesn't need to be any mental or physical evidence of anything occurring. So, however, if it's a survivor of sexual violence, there's no credible threat, then you do need documentation. And that frequently includes police, medical, or court evidence, a statement from a victim service provider. And so I understand, I think I understand kind of the underlying question. I don't want to assume, but something that I sometimes hear from housing providers is like, well, aren't people going to game the system? Or like, isn't this unfair? Or, people are just going to be terminating their lease left and right. From doing this work, for, I don't know, about 7 years now, it's my experience that I haven't seen that happen. I haven't seen that happen on a large scale, but also not on a small scale. And there's a number of reasons for that. Normally, when a lease termination situation comes up, the housing provider may have their own evidence of what's happening, or may otherwise be aware of it from neighbors complaining, from maybe police coming to the property, from the survivor asking for help. They may have seen things on their own of kind of the violence in the relationship. So a lot of times that just already exists. And so the landlord has this, even though it's not needed by the law, the landlord has this other kind of confirmation of what's happening. And then the other side of that is it's expensive to move. You know what I mean? Like, it's expensive to get a new unit. There's application fees, there's new security deposit, you have to pay first month rent. Sometimes you have to pay for a moving truck. There's just so much cost to that it's really a disincentive from utilizing this. So I think that's a variety of reasons that I don't typically see issues like that come up. But I'm happy to answer more questions about that. Okay, so I understand your point. Like I said, I haven't seen that. Although I do think that um sure, I understand your point that occasionally there's people that try to work the system. I don't see that happening regularly and or anything like that under the confines of the law. Okay. All right. So jumping back into this. So if someone's applying to subsidized housing, and with VAWA 2022, we're really covering all federal subsidized housing here. And so if someone has a barrier to housing eligibility, then VAWA does have a number of protections about that. And I see this come up a lot, sometimes with evictions, sometimes with justice involvement, because remember, there's a lot of barriers to entering subsidized housing. There's so many rules around the programs. And so if someone's denied from federally subsidized housing, they're supposed to get a notice of occupancy rights at that denial about VAWA protections. At that point, at the point of the denial, the survivor should fill out the form from HUD. It's the 5382 form, and they can request VAWA protection. They can explain why the issue is related to gender-based violence. And hopefully that should resolve it. And hopefully they get a meeting, they can talk through what the issue is. Like I said, I do see that come up a lot. Or you might have like debt on the background that raises a flag that's related to financial abuse. So a lot of reasons that someone might get a denial there. The last thing I'll say about barriers to housing eligibility is that as I work with people day to day, I encourage them to proactively address barriers, trying to repair credit issues, debt issues. If there's justice involvement, working on expunging and sealing when you can. Obviously, there's time limitations to that. Sometimes there's not a legal pathway to relief. And so if that's the case, if I'm trying to help someone get into housing, because I've had people that are stuck at shelter before because they can't get anyone to rent to them due to, like, for example, an eviction. Sometimes I'll write a letter, just obviously with the survivor support and with them wanting to do it, just explaining what happened, why it's there. And I've had positive responses to that. All right. I'm also trying to be cognizant of the time and make flexibility for questions later too. So next topic, preventing eviction. So someone comes to you, they have a notice, or potentially they're in eviction court, they're going to eviction court. I will flag that there is currently in Cook County, CCLAD, the Cook County Housing Legal Aid and Debt. But there's a hotline and a number where you can call and potentially get connected to an attorney and rental assistant. So I'll put that out there, but there's also a number of protections in the law for survivors that might be facing eviction. If you're looking at just a private market unit, we have the Illinois Eviction Act, which has a defense for survivors. It includes domestic violence, sexual violence, dating violence, and stalking. And it does not allow eviction based on being a survivor, an incident of a gender-based violence, or criminal activity related to that. If a survivor pleads this defense in court, they have to support it. And it's the same standard that you see with the lock change. It has to be medical, court, or police records, or a statement from a victim service provider or medical professional. So that's for private market units, although of course you could raise it for any unit in Illinois. For federally subsidized units, we're again going to go back to VAWA, which has protections here. It again pretty broadly protects survivors of gender-based violence. It also protects affiliated individuals. And so affiliated individuals can be a spouse, parent, a child, guardian. The violence may have happened to someone else in the household, and VAWA may still protect them based on this affiliated individual's umbrella. It provides very similar protections to the Illinois Act. You can't terminate someone based on gender-based violence. You can't deny them based on criminal activity related to gender-based violence. And gender-based violence is not a serious or repeated lease violation. We see that a lot with property damage, noise disturbances, things like that. Again, you can support the request with HUD form 5382. Last thing I'll say about evictions is that there's also other protections that could apply in other cases as well, like the Fair Housing Act. A lot of times if someone takes adverse actions against survivors, you can potentially raise a sex discrimination claim, mainly because survivors are disproportionately women. And so when you take adverse actions against survivors or have policies against them, it disproportionately affects women, and then that means it's sex discrimination. It's also sexual harassment protections in the Fair Housing Act and all of the other fair housing protections in our area. So that can sometimes be a defense to an eviction. Like I've often represented survivors that have also experienced sexual harassment. And so sometimes that can be a defense there. There's also retaliation protections. And so what I see a lot is if a survivor might be renting from like maybe an in-law or from the perpetrator themselves. And then they'll file an eviction after the survivor gets an order of protection. There are some broad retaliation protections, like for example, the RLTO in Chicago has a catch-all provision. And so you could potentially have a defense there. Okay. Yes, you will get the PowerPoint, Edward. I will give it to Gianna and you will have it. All right, so next couple slides are about VAWA. So remember, VAWA is always only subsidized housing. So sometimes like I'll be working on a case or working with a survivor, I'm like, oh, okay, we can use VAWA here. And then I'm like, oh, wait, it's not subsidized housing. So I also have to remind myself of that. So VAWA does allow people to split the lease. It allows housing providers to continue providing assistance to a survivor and removing the person that's causing harm. Does not matter who signed the lease. Survivor is not supposed to be penalized for the bifurcation. And housing provider still has to follow the lawful processes when removing someone. That means an eviction notice, proper service, going to court, an eviction order, or a settlement where they move out. You can't just take someone's stuff out. So, and I just have a common timeline there. Bifurcation is a really complicated thing that a lot of housing providers struggle with, just because there's a lot of moving parts. I usually recommend that the housing provider work with the survivor, kind of safety plan around the situation, figure out where the survivor is going to go while the potential eviction is happening. And then at that point, usually the provider kicks off kind of the potential eviction process against the perpetrator. All right, so VAWA transfers. So if you're in subsidized housing under VAWA, you have the right to move with your subsidy. VAWA transfers are really dependent on the subsidy that you have. So if you have a voucher, you're probably just going to be issued a new voucher if you have a VAWA issue. If you live in public housing, then the housing authority usually has kind of an eagle eye over what properties are available. If you live in project-based Section 8, that can be really difficult to transfer in. I'm trying to work on a global solution in our area, but a lot of times you have to kind of connect owner to owner, which can be really difficult. But survivors are eligible for transfer if they reasonably believe that there's a threat of imminent harm from further violence, or if there's a sexual assault on the premises within 90 days. So in order to request that, they're supposed to request it explicitly, and housing providers can ask for documentation. If they do, survivors have their choice of what they want to provide, but most people use HUD's 5383 form. Looks very similar to the 5382 form. It's kind of a simple, they're both like 10 to 12 questions, I think. But usually most of it's kind of basic information. And then there's a section at the bottom that allows them to explain why they feel unsafe at their unit. So I always like to say survivors are the ones that determine what the unit's safe for them. And that depends on a variety of factors. I was once working with a survivor, and a unit was identified to her, and housing authority was like, well, and so she saw the unit. She said, the perpetrator, he works about a block away. I know I will see him if I move there. He's going to immediately know where I am. And so it's just like an example of there's a lot of factors that go into what safety is, and it really depends on so many things. And also there's no limit on the number of transfers a survivor can get. So a lot of times people need more than one. Perpetrators can be really creative about how they get people's information. I once was working with someone who was facing termination because someone called a housing authority's fraud line and said that she wasn't living at her unit, just over and over again every time she moved. And he would like find out her address, and there would be a lot of surveillance, but it was just really difficult to her. But my point is there's no limit on the number of times people need to move. Last thing I'll say is a lot of times, especially if you're working with a voucher, you may have to access other protections. So you may need to, terminate the lease to be able to move with the voucher. You may need to request a lock change, like if you're in project-based Section 8. There's a lot of ways that these laws work together, so it's just something to keep in mind. So the last thing I'm going to say before I kick it over is there's other housing protections for survivors too, outside of kind of the ones that we think about a lot. The first one is Illinois allows for deferral of utility deposits. Through this protection, only domestic violence survivors. It says domestic violence in the statute. Most of what I talked about today applies to the broader umbrella of gender-based violence, but not this one. So it allows domestic violence survivors to defer their utility deposits 60 days. Illinois also has crime-free ordinance protection, so it prohibits municipalities and counties from penalizing landlords and tenants from contacting the police for emergency services. I could talk about crime-free ordinances for a while, but I won't because it's a very meaty topic that we don't have time for. But if you ever have any questions, let me know. It's also the Gender Violence Act. So a lot of people don't feel like they've been made whole by the criminal justice system if they've been a victim of crime. So the Gender Violence Act does allow survivors to bring a civil case against someone that harmed them or threatened to harm them. It's usually a battery or an attempted battery. So since it's a civil case, people have control over, what's said in the complaint, how it's brought, how it's resolved. So a lot of survivors use that. Illinois Consumer Fraud Act, so it prevents unfair or deceptive practices against tenants. I see this with survivors sometimes. For example, if someone's lawfully terminated their lease and then the landlord's trying to collect thousands of dollars from them for, accruing rent, it's an unfair practice because it's been a lawful lease termination. And it comes up in some other contexts too. But last thing I'll say is that Illinois does allow survivors to file under a pseudonym as long as they have good cause to do so. There's a lot of reasons why survivors would want to file as like a Jane Doe when they file a complaint, including fear of retaliation, kind of concerns for their safety, and not wanting to disclose deeply personal facts. And so that is a protection that's available in Illinois. All right, I guess we'll save questions to the end for after Noreen, but thank you so much. And if you ever have any questions about any of this, or you're working with a survivor, please reach out to me.
Thank you, Jackie. And Noreen will, you can share your screen now, excuse me.
So thanks. Hi, everybody. My name is Noreen Kim. I'm the Director of Housing at North Suburban Legal Aid Clinic. I just want to forewarn you that I am notoriously bad at multitasking, so I cannot monitor the chat and the Q&A. I can only do the PowerPoint at one time. So if you need anything, just like chime in, or else let's wait to the end for questions. So 1 second while I share my screen. All right. So like I said, I work at North Suburban Legal Aid Clinic, and I'm going to be talking today about housing protections specifically for immigrant households. So just a little bit about what we do. We're a free legal services provider. We represent people in the areas of domestic violence, housing, and immigration. I've been doing legal services for, I think, over 20 years, maybe like closer to 25 even. And I've worked at many different legal services agencies, including LAF, where Jackie worked, although we didn't overlap, and Legal Aid Society in Chicago. And I actually started off as a public defender doing criminal defense work. I've been focusing mainly in housing for, I think, the past 8 or 9 years, but it really gets away from me. But now that I'm working at North Suburban Legal Aid Clinic, we are in Lake County and North Suburban Cook County, and we are not a legal services provider that receives money and funding from the Legal Services Corporation. So a lot of the bigger legal services agencies like Legal Aid Chicago now, everything has been rebranded. But since we don't receive funding from those sources, we can represent undocumented clients. And so many of the people that I help with housing issues are in fact undocumented. So here's the topics that we're going to be covering in, I think, the next half hour or so. Fair housing, federal and state, the Immigrant Tenant Protection Act, public charge, and federal housing and immigration status. So there are over 1.8 million immigrants in Illinois. That's about 14% of our state's population. And Illinois actually has the 5th largest foreign-born population in the US. And roughly 511,000 of those immigrants are undocumented. There's been a big shift of the immigrant population moving from the urban areas, from Chicago to the suburban areas and throughout the rest of the state of Illinois. And right now, more than half of Illinois' undocumented population does in fact live in the Chicagoland suburbs. So I'm going to start with talking about fair housing, which obviously you all probably know a lot about. I'm going to go back to the basics because I think it's just important to just do a review in the context of immigrant households specifically. So obviously, fair housing is the right to choose housing free from discrimination. And discrimination is when you unfairly treat one group of people or persons differently from other people or persons. So there are federal, state, and local fair housing laws which protect people from discrimination. And that's in housing transactions such as rentals, when you buy a property, lending, and also insurance. So the federal law is the Fair Housing Act, and that's enforced by HUD, the Department of Housing and Urban Development. The state law that governs is the Illinois Human Rights Act, which I think you've learned a lot about, which is enforced by the Illinois Department of Human Rights. And then there are local ordinances throughout the state and those are enforced by local governments. So for example, Chicago or Cook County. Fair housing laws cover most housing, but not all. So there are some exceptions. And specifically owner-occupied buildings with 4 units or less. And I think that sometimes affects our immigrant population because a lot of them are in some of these smaller mom and pop renting situations. Housing operated by religious organizations and private clubs, housing for people with disabilities, and housing for seniors. The Fair Housing Act is the federal law that governs, and that was enacted in 1968. It protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in any other housing-related activities. And the protected classes include race, color, national origin, religion, sex, familial status, and disability. So as you can see, immigration status is not a protected class, but often the issues that immigrant families experience are covered under national origin. So it's illegal discrimination to do any of the following: refuse to rent, set different terms, conditions, or privileges for a rental, falsely deny that housing is available for rent, imposing different rent amounts, evicting a tenant or a tenant's guest, harassing a person, failing or delaying performance of maintenance or repairs. I see this a lot with immigrant tenants where their landlords don't feel like they have to prioritize them and do any repairs. Limit privileges, services, or facilities of a rental, discourage somebody from renting, or using different qualification criteria or applications. Different rentals standards or procedures, such as like income standards, application requirements, things like that. It's also illegal to threaten, coerce, intimidate, or interfere with anyone exercising their fair housing rights, or to retaliate against a tenant who has filed a fair housing complaint. So you can file a complaint with HUD, the Office of Fair Housing and Equal Opportunity, if you have a Fair Housing Act complaint. So the state law that governs is the Illinois Human Rights Act, right? That was enacted in 1979. This is our state law that prohibits discrimination in Illinois. It encompasses more than just housing. It's employment, financial credit, public accommodations that I think you've already learned about, housing, and sexual harassment. And there's a long list that's governed under the Illinois Human Rights Act. It's more fleshed out. That includes race, color, religion, national origin and ancestry, age, sex, marital status, order of protection status, like Jackie just talked about, disability, military status, sexual orientation, pregnancy, unfavorable discharge from military service, familial status, arrest record, and source of income discrimination, which you've also learned about. So again, immigration status, not a protected class. National origin and ancestry, though, are things that usually cover an immigrant household. So for the Illinois Human Rights Act, you can file a complaint with the Illinois Department of Human Rights. What they do is they conduct an investigation of the discrimination. And if there is substantial evidence, they'll file a complaint with the Illinois Human Rights Commission, or at that time, you could file a lawsuit in court. And the Illinois Human Rights Commission is then the body that does the actual review and does the adjudication. So as I mentioned, immigration status, not specifically a protected class, but national origin and ancestry are what you can focus on. And so landlords cannot discriminate against you because of national origin, which is the country you are from, or ancestry, which is where your ancestors are from. So here are some examples of discrimination that are based on national origin or ancestry. If a building manager, for example, were to waive fees and deposits for some tenants, but not for tenants from India. If you charged Latino tenants higher rent than they charge other tenants for the exact same unit, or denying access to the building parking lot to tenants who were born outside of the United States. So here are some relief that a tenant could get by filing a fair housing complaint. Money, granting an accommodation request, approving a housing application, setting a rule that a building might need to train housing providers, posting information on fair housing in common areas, or other types of relief. Okay, so the next thing we're going to talk about is the Immigrant Tenant Protection Act. This is a state law. It was enacted more recently in 2019. And again, this is an Illinois law that prohibits landlords from basically doing anything to a tenant because specifically of their immigration status, right? So they cannot evict or threaten to evict a tenant because of their immigration status. A landlord cannot use a tenant's immigration status to intimidate or to force a tenant to move. And a landlord cannot harass, intimidate, or threaten to disclose a tenant's immigration status. A landlord cannot call ICE or threaten to call ICE, increase rent, shut off utilities, or refuse to make repairs because of a tenant's immigration status. So what can a tenant do if they are facing illegal acts by their landlord because of their immigration status? They could file a lawsuit under the Immigrant Tenant Protection Act, and they can get money. And so they can get actual damages for any injury or loss that they suffered. They can get an additional penalty of up to $2,000 for each violation. And also they can get attorney's fees and court costs, basically that the landlord has to pay for any fees that the tenant incurred by filing the lawsuit. How I usually see the Immigrant Tenant Protection Act, though, is as an affirmative defense. So if a tenant is already in court because their landlord has brought them into court to evict them, you can raise an affirmative defense of retaliation on the basis of immigration status. And so the Eviction Act specifically creates this affirmative defense. And that is when the eviction is based solely or in part on the citizenship or immigration status of the tenant, or if the eviction is based solely or in part on the tenant's failure to provide a social security number, information required to obtain a consumer credit report, or a form of identification that the landlord wants. So, obviously, if you're an immigrant tenant and you do not have a social security number, a landlord can't just ask you for your social security number. They have to accept other forms of identification or documentation. Okay, moving along to public charge. So public charge is a reason in immigration law that a person could be denied a green card, visa, or admission into the United States. So in determining whether to grant some applicants a green card or visa, an immigration officer must decide whether that person is likely to become dependent on certain government benefits in the future, which would then make them a public charge. So public charge only applies to those who are applying for a visa to enter the United States. They're applying for legal permanent residence or green card through a family member, or they are already an LPR who's left the United States for more than 180 days and is returning back into the country. So that's it. It only applies to these three categories. So if you are trying to file under a U visa for domestic violence, a T visa for trafficking, you're an asylee or a refugee, public charge does not apply. So there's been a lot of change and turmoil over the public charge rule, which has led to some confusion. So I'm just going to do a brief history of the public charge rule. There was a new rule that was published in August of 2019 that went into effect in February of 2020. And this was the public charge rule that created a lot of press and attention because it expanded their criteria for becoming a public charge to whether a green card or visa applicant was likely to rely on government benefits in the future. On March 14th of 2021, the 2019 public charge rule was removed. And on September 9th of 2022, a final rule on public charge was published that is scheduled to go into effect on December 23rd, 2022. And until then, the 1999 field guidance, which was sort of the long-standing prior public charge policy, is the one that remains in effect. So the only public benefits that are considered in the public charge test right now are cash assistance programs that provide ongoing payments, such as SSI, Supplemental Security Income, TANF, Temporary Assistance for Needy Families program, and general assistance. And also long-term institutional care, like a nursing home that is at the government expense. These are Illinois public benefits that are not considered for public charge. And that includes Medicaid and any Medicaid-like programs, all kids, moms and babies, charity care and hospital financial assistance programs, healthcare from community health centers, COVID testing, vaccines, any treatment related to that, home and community-based services, rehabilitation services, SNAP, WIC, free or reduced school meals, food banks, or any type of free meals. And this is also assistance available to all immigrants, not considered public charge, and they're available to all immigrant families because of this. They're necessary to protect life or safety, and that includes emergency rental assistance and mortgage assistance, LIHEAP, utility assistance, emergency shelters, rapid rehousing, transitional housing, short-term housing assistance, crisis counseling and intervention, treatment of mental illness and substance abuse, and services and assistance relating to child protection, adult protective services, so for seniors or disabled, violence and abuse prevention, victims of domestic violence, sexual assault, human trafficking, or other criminal activity. Okay, and lastly, we're going to be talking about federal housing and immigration status. So I thought it was helpful maybe just to do a really quick sort of recap of the three main types of federally subsidized housing. There is public housing, which is owned and operated by public housing authorities. For example, the Chicago Housing Authority or the Housing Authority of Cook County. These are what are called project-based subsidies, which means that somebody gets a subsidy for a specific unit in a specific building, and it's for that unit in that building only. There's also something called Section 8 project-based, which are when private owners enter into contracts with HUD. And these are also, again, project-based subsidies, a specific unit in a specific building. There's also something called Section 8 tenant-based, which are when HUD enters into contracts with public housing authorities. And these are tenant-based subsidies, which are a little different because the subsidy can move around with the tenant. So the tenant can choose a unit here, and then they can move around and choose a different unit. And so the big program that most people are familiar with is the Housing Choice Voucher Program, where the tenant will find a place to rent in the private market. They'll sign a lease with a private landlord, just like anybody else would, but then that landlord enters into a contract also with the housing authority, and the landlord gets paid both by the housing authority and then by the tenant. There's also the project-based voucher program, which is a project-based subsidy. It is a specific unit in a building, but a tenant can get a housing choice voucher after they live there for a year. There's also VASH, the Veterans Affairs Supportive Housing. And then there's other federal housing programs too, right? There's the Section 202, which is for seniors, Section 811 for people with disabilities. And there's just a long list. I think you all probably are familiar with many of these different types of federally subsidized housing programs. And then there's also, of course, other state and local programs. So most federally subsidized housing restricts assistance to citizens and non-citizens who have eligible immigration status, like their LPRs, or one of the other eligible criteria. And so this includes public housing, Section 8 project-based, Section 8 tenant-based, and Section 236 housing. So undocumented immigrants are not eligible for most federally subsidized programs, but they can live with family members who are eligible. And that's called mixed status households. So a mixed status household includes eligible members with citizenship or immigration status who receive the housing subsidy. And then it can also include ineligible household members who, based on their immigration status, will not receive the subsidy. And so then the rent in a mixed status household is prorated. The housing subsidy is prorated to exclude the ineligible person or persons from the assistance. Now, there are some federally subsidized programs that do not restrict housing assistance based on immigration status. And this includes the CDBG fund, Community Development Block Grant, home housing opportunities for persons with AIDS, Section 202, senior housing, Section 811, housing for those who are disabled. All of these programs do not restrict. So you do not need to have eligible immigration status to apply to these housing programs. However, one thing to keep in mind is that some of these housing are financed by or by other federal housing programs, which may restrict based on immigration status. So, for example, there may be a building that's has units that are low-income housing tax credit units, but they also are receiving a different type of federal subsidy that does not allow you to rent to people without immigration status. And that means that all of the low-income housing tax credit units also cannot be then rented out to those without immigration status. Okay, so lastly, I just wanted to let people know if you do have clients in our service area, which is again Lake County and North Suburban Cook County, that you can send clients over to us for assistance in housing. We are one of the few legal services providers in our area who can help undocumented tenants. So I just wanted to put that out there. And then lastly is my contact information. You can feel free to reach out to me if you have any questions about what we talked about today, or just questions in general. Like Jackie, I mean, this is what I do, and I'm always happy to answer questions and to make your job easier, because we work in tandem together to try to help people.